Yeah. Where is everybody? Well, yeah, it did make me think.
Hi.
Hi there.
Good, nice to see you again.
Thanks. Good. Zoom's going.
Yeah.
All right, thank you. Good afternoon, everyone. Apologize for the lateness, although actually 10 minutes after, that's about when we learn some of these things. Anyway, my name is Ed Getz. I'm the director of the Center for Urban and Regional Affairs at the University of Minnesota. And welcome to the CURA Housing Forum. CURA Housing Forum is a forum that we try to put on once a month during the academic year. And it covers topics of interest in the housing field, local interests, sometimes national interests. It can involve research being done at the university or significant topics that are being addressed by housing practitioners in the region, new policies, et cetera. Today's topic, as you see on the screen, is exploring the impacts of the RealPage antitrust case. And we have two speakers today. The first is Larry McDonough, who is a senior fellow at the National Housing Law Project and a policy attorney for Homeline. And the second speaker we have is Jordan Ash, who works at the Private Equity Stakeholders Project. And they will bring their unique perspectives to this issue, and then we'll have an opportunity for question and answer. So I will give it over to Larry at this point. Thank you.
Ed, thanks for having us here. Thanks for those of you that are in person and those that are streaming. So we'll just get started into it. If you don't know anything about RealPage or the litigation or what's going on in housing related to that, hopefully we'll kind of bring some of that to light today. So here's some contact information on me. I'm happy to continue the discussion afterwards, either today or another time. I can be reached. I'm an adjunct professor at the University of Minnesota Law School, kind of on the other side of the road there. And got my bio here, but of course, like anybody else's, it's a pack of lies. So you can just read that from joining. So I'm going to talk to you a little bit about the history of landlords and tenants and the evolution of corporate management in the housing area. And then Jordan's going to talk a little bit more specifically about how RealPage operates. And then we'll talk a little bit about the litigation that's going on right now. So landlord-tenant relationships go back a long ways. Basically, as soon as people decided that they thought they ought to be able to own property and wanted to make money off of property, one way to make money off of property is to own a bunch of property and then have other people use that property and pay for it. And so you start to see that evolve basically in England and some of the other European countries as far back as, year 1000. And in English history, it really starts to kind of take hold around 1066. It's most of when Europeans basically invaded what's now the United States and brought their cultures and laws to play here. The concepts of ownership of property came here as well. Minnesota started to regulate landlord-tenant relationships even before it was a state. Our laws in here from European-based law dates back to the territorial laws of 1851. There was a small section there on landlords and tenants. Most of that really had to do with agricultural tenancies. If someone owned some farmland and then they would rent it out to somebody else, and that person would then farm the land. And the landlords had very few responsibilities on their shoulders. I think the concepts were that the farmer tenant would then build the buildings and maintain the structures and farm the land. And so the owner didn't have an obligation, for instance, to maintain those facilities that the farmer tenant was organizing. And so that's essentially the way it stayed here for and around the country for a long time. When you study landlord-tenant law, it's really more of a state-by-state or city-by-city analysis. There's very little national landlord-tenant law in the United States. So Minnesota, our laws date back to 1851, and they've grown a lot since then. But they essentially stayed, I'd say, in a little bit of a frozen state until around 1971. So basically about 120 years, the laws in Minnesota didn't change that much. And usually the laws are behind changes that are going on in society. And so you see that landlord-tenant relationships become more of an urban entity. They're still an agricultural entity, but by sheer numbers, it was more of an urban phenomenon, really by, I would say, the late 1800s into the early 1900s. But it took that long for the laws of Minnesota to finally kind of catch up and recognize that. So we have our first law that requires landlords to maintain properties in reasonable repair. That comes to play in the early 1970s. So up to then, landlords did not have an obligation in Minnesota laws to do that. There were some court cases that talked about it, but the legislature hadn't spoken on it. So then you start to see this evolution of laws, both in Minnesota and around the country, that really develop more tenant rights. So presently in Minnesota, tenants will have the rights, they have rights to privacy, they have rights to reasonable repair, they have a right to call for emergency assistance, they have a right to get out of your lease early if you're a victim of domestic violence. A recent law allows people with infirmities to get out of their leases early to, for instance, go to a nursing home or something like that. All that evolution in Minnesota happened in essentially, the last 50 years or so. So, and when I first started practicing in the early 80s, I wasn't dealing really much with corporate landlords. And if I were, they were local. Okay, so you might have a local landlord that develops its own LLC and then it operates that way. But I really wasn't running into corporate entities from outside of Minnesota probably for about 15 years ago. So let's talk a little bit about the evolution of national and regional corporate ownership. And so I've got a few quotes from some scholarly pieces on it that kind of tell you kind of what happened. So from the National Low Income Housing Coalition, in the wake of the 2008 global financial crisis, the United States experienced a surge in foreclosures and family-owned homes, followed by the acquisition of these properties by investors seeking to operate them as rental properties. So I think a lot of people are aware of the foreclosure crisis that was going on in that time period. I think not a lot of people outside of the industry were really aware of what happened after that. And what happened after that was really a surge in larger national companies buying up properties, both single family homes and also buying up apartment buildings, and then managing them and operating them on a national level. And you see the same thing in a piece by the Homes for All campaign, where they're seeing, again, a big influx of national entities purchasing properties and having this, large spread of properties throughout the country. Now, what we'll talk about in a few minutes with RealPage is, at this point, 15 years ago, there wasn't much coordination going on between these entities. And what's really new in what's going on with RealPage and the RealPage litigation is basically an investigation analysis of whether they are basically colluding to kind of set their own prices and to set their own policies. Now, some of the downsides, in my view, and also the Homes for All campaign, is some of the effects that can come when you have more consolidated ownership of rental property throughout the country. And they list a few things here: higher rental costs, limited experience in maintaining property and complying with local laws, and tenants having to, as these investors kind of buy and sell their properties, new tenants are having to deal with kind of a revolving door of that. Now, for people that own their own homes, they're probably familiar with the change in mortgage holders. So for instance, I own a house in St. Paul. I've had it since 2005. I can't even tell you how many times the mortgage management of that has changed over the years. It's probably changed 5 or 6 times. It doesn't impact me directly because I'm paying the same mortgage payment. But if you could see that revolving door happening in terms of the ownership of property, you're going to have tenants dealing with different rules, different management things, and different rents. And I've seen this in my own practice. I had a case up in Bemidji a couple of years ago, and this wasn't a national ownership corporation. It was a regional one out of Fargo. So they're managing this property in Bemidji, and the tenants up there don't have any person on site to ask about repairs. They have to submit the repair request to a portal, and then the company in Fargo sends out a contractor to look at things. But that person's scope of responsibility is limited to whatever corporate said. And so that person comes out and says, well, yeah, you know, we need to work on this, but these things also need some work too. Oh, can you work on that? Well, no, I haven't been hired to do that. So I guess you're gonna have to go through the portal again. Okay. And so I had this case where there's basically a security door had been damaged, and some people were coming and trespassing and living in a boiler room, and it caught on fire, and it basically knocked out the heating system, and management in Fargo was very slow to deal with. So we had to sue them to basically get them to hire people to come and fix it up. And this wasn't even a national one, this was a regional one. Another case recently was a national company that was buying up manufactured home parks around the country. So in a manufactured home park, usually people own a mobile home or a manufactured home, and then they rent the spot on which it sits. So that's the landlord-tenant relationship, is between the park owner and the owner of the mobile home that's sitting in the park. So we had a case in Northfield where this national company came in and said it's going to make bought it, we're going to make all these changes, and we're going to make you do the leases and everything. And they hadn't taken the time to actually look at Minnesota law on manufactured home parks, which provides more protection to manufactured home residents and other tenants, because if you have to move, you have to move your manufactured home with you. And most manufactured homes are not built for the ages. So you go back and you look at old buildings in Rome, none of them are mobile homes. Okay? They weren't built for that kind of tenure. And most mobile homes, if they're beyond a certain age, if you have a crane, try to pick it up and put it on a flatbed, it's going to collapse on itself. Okay. And so this company hadn't done any work at figuring out that it couldn't do the things it wanted to do, but it was telling people they were going to do them anyway. And it wasn't until they were getting threatened with a lawsuit, both from a residents group and also from the Attorney General, that they actually backed off. So that's just what I've seen locally on what's been going on here with this kind of evolution of national or regional kind of corporate entities buying up properties. So I just want to say a little bit about what's going on with RealPage. I'm going to hand it over to Jordan. I was not that familiar with RealPage until just a couple of years ago. And ProPublica did an investigation of what RealPage is. And so you can just kind of look at the quotes here from that article. And if you get an electronic version of this slideshow, all these links that are on here are active. And so if you click on those, it'll take you to the source material. But basically what's going on is that RealPage has, it basically gets the large landlords together with the idea that if you give us your information about your practices, we can coordinate that with the other large landlords. And then we will basically recommend to you how you ought to run your place in terms of what your prices ought to be, what your rents ought to be. And so essentially what this is doing, and what the litigation that we'll talk about, after Jordan talks, is essentially price fixing. And so I think I'll kind of leave it at that and then have Jordan take over, and then we'll talk a little bit about litigation that's going on, not just with the Department of Justice, but a number of attorney generals from around the country have brought their own litigation against what RealPage is doing.
Thank you. It's great to be here. My name is Jordan Ash. I am with the Private Equity Stakeholder Project. I'm based in Minnesota, but we're a national group. And we're a nonprofit watchdog organization that focuses on the impact of private equity in 5 issue areas: housing, labor, climate, healthcare, and detention. And I lead our work on housing issues, and I'll explain more about what private equity is in a little bit. It's the type of thing you might have heard the term a lot, but usually, unless you're making money from it, people aren't that familiar with it. A couple things just real quick, just to kind of add on to what Larry was saying that kind of struck me about RealPage and from that ProPublica article, was that it's really set up to maximize rent. And it's been clear, and the people at RealPage are very clear about it, the people who use RealPage are very clear about it, that the rent is higher than they would have set otherwise. That using this formula actually is the goal of actually having it be higher rent than they would otherwise in order for all of them to make money. One of the other noteworthy things is that, so with RealPage, landlords report their rents to it in other terms, and then the algorithm suggests how much they should be charging for rent for similarly based on number of bedrooms and square footage. And the companies that subscribe to RealPage that are part of it are obligated to accept that rent. You're not given the choice about it. That the system only works, basically, they say, if everybody is bought into it and everybody is going to agree to use these rents, with the goal of, again, kind of maximizing, profits for everybody. And Larry will talk about in terms of, with the antitrust thing, it kind of takes out the competition in terms of deciding, competing for tenants. So for instance, when you see signs, first month rent free or, free cable, those are all things that landlords do in order to get customers, to get tenants, and it takes that part away. So you're not allowed to just decide, if you're a participating landlord in it. It also maximizes, the use of vacancy that it recognizes, and it formulates that into the algorithm about how that's good for the market, how many units should be vacant, and whether particular landlords should agree. So even if rent it seems like it's set too high and people aren't responding, that's okay according to the algorithm at times to have that vacancy in terms of increasing the demand. Go to this next one here. So the way that it works is kind of a hub and spoke thing where the companies are not talking to each other. They're basically using RealPage in the hub, and the landlords are reporting their information to the hub, and then RealPage is kind of sending the information back out to them about how much they should be charging. And there's been about 30, as Larry's going to talk more about, 30 private lawsuits against RealPage. The Arizona and Washington, D.C. attorney generals have brought cases, in addition to the Department of Justice recently and 8 other attorneys general. And in a number of those cases, there are particular other landlords, in addition to RealPage, that are named as defendants. And just to kind of look at some of the landlords that are named in it, you can see how large they are. So I did up this chart. This is, again, just kind of landlords that are named as defendants. And these are specifically the ones that are actually active or present in the Twin Cities. So there are some other ones also that aren't here. The column on the left-hand column is the rankings from the National Multifamily Housing Council for the largest property managers. You can see that 4 of the 5 largest, landlords in the U.S. or property managers in the U.S. are here in Minnesota. Nationally, these 4 companies alone manage about 5,500 properties with a total of 1.4 million units. So when Larry was talking about the consolidation that we've seen and the growth of companies, these are huge numbers, just in terms of the evolution from when it was mom and pop or regional companies. These are huge numbers. And in the Twin Cities, these 11 companies own 171 properties with almost a total of almost 36,000 units. And again, these are not the only landlords that use RealPage, just the ones that are named as defendants that are in the Twin Cities. I'm gonna asterisk next to the companies that are owned by private equity firms. 7 of the 11 companies are here are owned by private equity firms, and that's, when we look at RealPage, that's really kind of what we're looking at, is the role of private equity in this. One of the companies, BH Management, was bought this year by the private equity firm Pretium Partners, which already owns the single-family rental company Progress Residential. Progress is the company that the Minneapolis tenants group Inquilinos Unidos was organizing tenants of, and that Attorney General Keith Ellison reached a large settlement with for under-maintaining over 600 single-family rental homes and falsely promising maintenance services. I also want to talk about one company that's not listed here. For some reason, and Larry, you might be able to offer more insight into this. The various RealPage lawsuits only name property managers as defendants, or owners who are also property managers, such as Greystar, but it does not name any companies that are strictly property owners. The largest owner of rental property in the US is the private equity giant Blackstone, which owns about 350,000 total units. And I know I just showed on this slide that, says Greystar 800,000. So that's the number of units they manage. They actually own about 100,000 of those, but they manage 800,000. In terms of pure ownership, Blackstone now owns 350,000. It's about 3 times more than the next largest, Greystar. And Blackstone is often confused with BlackRock. They're similar but different in terms of what they do, and they're completely separate companies, but it's very confusing. One of them should definitely change their name. So Blackstone is also the largest private equity firm in the world. And you can see here in terms of 350,000 total units in each of these different areas. So multifamily, 90,000 units of affordable subsidized housing. So housing that was bought, built or refinanced with low-income housing tax credits. 66,000 single-family homes. They're the 3rd largest company now for single-family rentals, and 35,000 student housing units, in addition to 13,000 manufactured housing lots. They're not usually cited as the largest landlord because those figures come from the National Multifamily Housing Council, and Blackstone does not report its numbers to that. But it's clear that Blackstone is using RealPage. Again, kind of not sure what, we think that they really got off the hook by not being named in any of these lawsuits. But these are the property managers named in some of the RealPage lawsuits and Blackstone's use of them. So it's about 115,000 total units that Blackstone has companies, property managers who've been named in the RealPage lawsuits. And I've mentioned several times about companies that are owned by private equity firms. So private equity is a particular type of corporate landlord. Not all corporate landlords are owned by private equity companies, but a lot of them are. And while individual private equity firms vary a little in their business strategies, there's a kind of standard overall business model, which is to buy an asset for cheap and then increase its profitability as fast as possible, generally 3 to 7 years, to provide a return to their investors and pay back their debt. So in many cases, just kind of like property flipping. The goal is to resell that asset. So when they do strategies such as raising the rents, it's not just for that immediate revenue or profits. It's actually with the goal of increasing the profitability of that property in order to sell it. So it's both kind of short-term profits and the revenue, but also to make the overall asset, the overall property, more profitable. So it fits in a lot with the goals of RealPage and why private equity landlords are using RealPage. The way that private equity landlords increase the profitability is to raise rents and make tenants pay new fees in order to increase the revenue. And then they cut costs by neglecting maintenance repairs. They reduce staff, aggressively evict tenants who fall behind. One of the unique things about private equity is that it's considered so risky, the investment, that there are rules about who can invest in private equity funds. So I'm guessing that nobody here is actually wealthy enough to be able to be allowed to invest into private equity funds. It's only super wealthy folks or institutional investors like pension funds and university endowments. And public employee pension funds, such as for state, city, county, and school district employees, are particularly important in private equity and account for 2/3 of the capital raised for those funds. So one of the things that we do is to work with tenant unions and community organizations to bring their concerns with their private equity landlord to those pension funds and investors. One final aspect of private equity is that it is not transparent. They make very little information available about their investments. So in many cases, pension funds that invest in private equity don't know what the investment is being used for. So RealPage is also owned by a private equity company. It's called Thoma Bravo. So private equity firms own numerous companies in their portfolio. With Thoma Bravo, RealPage is just one of 80 software companies that they own. And they mentioned that private equity relies heavily on investments from public employee pension funds. Just wanted to show that a little bit more in the case of RealPage. So with private equity, investors don't invest in the company the way that you would, for instance, in buying shares in Target or US Bank or 3M. Instead, they invest in specific funds that the private equity companies are raising money for. And then the private equity company uses the money in those funds to acquire assets. So in the case of RealPage, Thoma Bravo acquired RealPage in 2021 using money that it raised from two funds, creatively named Fund 13 and Fund 14. More than 30 public employee pension funds invested in these two funds. So these are the largest investors. You can see it's huge amounts of money. And yes, you can see that one of the investors, although it's down there at the bottom, kind of cut off, conveniently, I guess, is the Minnesota State Board of Investment, which manages the retirement funds for all state, city, county, and school personnel in Minnesota. I should also note that for most of these pension funds, these are just two out of the multiple large investments they've made in Thoma Bravo's other funds. And one last thing here, just before I hand it back to Larry and go in a completely different direction, and I don't really have any transition for it, is that in response to the growing concern about RealPage, there have been legislative efforts this past year to ban RealPage at the federal, state, and local levels. So in February, Congress, in Congress this past February, several senators, including Amy Klobuchar, introduced a bill called the Preventing the Algorithmic Facilitation of Rental Housing Cartels Act, which would outlaw the use of algorithmic price setting software in the rental housing market. And on the state level, a bill in Colorado passed the House this year, but was defeated in the Senate. Bills were also introduced in California and New York state legislatures. And on the local level is where there's been kind of the most legislative activity, kind of spurred on by local tenant organizing. This past July, San Francisco became the first city to enact a law that bans the sale and use of software and algorithms to set rents. Last month, bills in Philadelphia and San Jose were introduced, and there's a number of other cities where they're looking at it too. Just one final thing, and then I'll turn it back to Larry, is that I'd also just say that, so we said we're a national organization. We work with groups around the country. The talk in Minnesota and the recognition in terms of the affordable housing crisis in Minnesota is going on everywhere. They're the same conversations, they're the same news articles looking at rents. And I think one of the reasons why there have been so many lawsuits and why there's such interest in it is that there's finally something to point to explain that we can do something about that gets at the root of in terms of affordable housing. There's so many different companies. Each one of them is, by themselves responsible in terms of for raising rents. But with RealPage, there is something there finally to be able to kind of do something about, to enact policy about, to litigate about, to regulate. But also the sad part is that it is not the end all. So even banning RealPage, unfortunately, is not going to, the RealPage software and algorithm has raised prices more than they would otherwise. But the companies, the landlords, are still looking to maximize rents themselves. Even without RealPage, they're still going to find ways to maximize rents. So thanks, and I'll turn it back over to Larry.
Yeah, thanks, Jordan. And In case you think we're just gonna be talking heads all day, we're not. I'll talk for maybe about another 5 minutes or so, and then we'll have a conversation with Ed and with you all about some of these things. So you might be thinking, okay, we're just bashing landlords today. Well, we're not. I've been a landlord myself. I have friends that are landlords. There certainly are bad landlords out there. I've litigated against slumlords. And not all corporate landlords are necessarily going to act badly. Okay? But what we're talking about here is a phenomenon where landlords are coordinating. And they're coordinating to, and it's one thing for a couple of landlords without market share just to say, well, you know, what do you rent at? Well, I'm renting at this. I mean, that is a little bit about how the market works. And when individuals are having those conversations or smaller entities are having that conversation, that's simply about figuring out what is the market. Okay, so you're going to set your rent at a level where you hopefully will meet your expenses, maybe make a little bit of money on top of that, and not price it so high that people aren't going to rent. Okay? Now, sometimes even without coordination, if you have a low vacancy rate, then landlords are going to have a little more ability to kind of set that price, and this because of a shortage of the available product. Okay? What we're really talking about here is a coordinated effort to really set prices and then have that be the market with people and entities with enough market power where they can do that. So most of the cases have been under the Sherman Act, and you may have heard of the Sherman Act. If you've studied United States history, either business history or just political history. So the Sherman Act comes out of the 1800s, and essentially it was an effort to combat the large corporations that were running the railroads and other entities and banking houses where they were big enough. And back in those days, it might be, you know, a few white guys at an athletic club in New York City having a conversation about what are the rates going to be for commercial hauling for railroads. And then they simply all decide we're going to do that. Everybody's going to be a good player. And then the rest of society deals with that. And so you essentially have an artificial kind of setting up a price rather than a market setting a price. Now, the Sherman Act was essentially a federal law to deal with that. So why did it take so long for this concept to come in housing? Well, it goes back to what I was talking about a little bit earlier, where housing was essentially a local thing with smaller players. So originally agricultural, later it's urban, but again, in my time practicing as an attorney the last 40 years, I wasn't seeing this 40 years ago. Really seeing it about 15 years ago. That you actually see that there could be landlord entities nationally that would have enough market share where if they all got together and coordinated, that would potentially be a Sherman Act violation. So that's why we're seeing that kind of analytical framework now, where we weren't seeing it, 20, 30 years ago. So what are the court cases? You might have just heard that the Justice Department filed a case in August, but that was not the first one. And this is not even all the cases here, but you're seeing cases in California. And when you see like a reference to a court case and they're a state and there are a couple letters in front of it, like SD California, and what that tells lawyers is that that's in federal court. It's in the Southern District of California. Now, most of these cases are for violations of the Sherman Act. So you see the Basin case from California, and then we have the Duffy case up in Washington. Those are Sherman Act cases. Now, the District of Columbia case is, so District of Columbia is Washington, D.C. It essentially operates kind of like a city and a state, okay? So it's not a state, but it's a district, but it has an attorney general, and it functions kind of like a state. And so there, the District of Columbia has its own antitrust act. And so the District of Columbia case was actually not a Sherman Act case. It was for a violation of DC's own antitrust act. Now, the state of Arizona case, I think is interesting in that that was another one that was that's all based under state law. So the DC case is district law. The Basin case is federal law, as is the Duffy case. Okay? Now, what's going on in Arizona case is they're challenging the practice based on Arizona's Antitrust Act, but also its Consumer Fraud Act. A lot of states have consumer laws, and Minnesota does too. We have a Prevention of Consumer Fraud Act in Minnesota, and we have a unlawful deceptive trade practices law in Minnesota. And you see a lot of these similar kind of laws around the country. And so Arizona was kind of taking a different approach. It was filing its case in state court, so in the Arizona Superior Court. That's kind of the lower court. In Minnesota, that would be called the district court. And so it could be that they decided they wanted to have this venue in state courts rather than federal courts, or maybe it was just an issue of we want to enforce our own laws. We don't necessarily need to have to enforce the federal laws. And again, if you get an electronic version of this, if you click on these links, you can see the complaints in these cases, and you can also see some of the press releases in the cases. And then the most recent case is the United States case versus RealPage. Now, that case is only against RealPage. As you can see, most of these other cases, when you have the case name and then you have et al. After that, that means there are other entities that are part of that case. And most of these cases have a whole string of defendants. The United States case is only against RealPage. It's also a Sherman Act case. So we see we got a mix of these cases, some going under federal law, the Sherman Act, some going under local law, either local antitrust law or local consumer protection law. So all these cases are pretty new. They're percolating through the court system. When you might think when you file a case, bam, stuff happens. For the most part, that's not how the court system works, because both sides have a period of time where they can investigate the other side's claims. They can do things that are called discovery, where they ask questions of the other side, have the other side produce documents. And so a lot of these cases are in that phase right now because they're pretty recent. So with that, that's kind of done with our prepared remarks. We're happy, however you want to kind of take it off from here, Ed.
We should all. And Ozma, how can we receive questions from? Great. All right. So you see on the screen a source to email questions, and they'll be relayed to us. There are people in the audience here today that will take questions from. I wanted to lead off though and ask if it's only large and or corporate or private equity landlords that are using RealPage, or is this extending beyond that in the market?
What I know is that it's not just the largest. I don't know that, for instance, if it's I'd say ones that, definitely landlords that own more than, properties more than 5 units. The estimates are that, for instance, that in Seattle area, that 90% of the housing, landlords that only 90% of the housing were using RealPage. So it definitely gets, gets lower than in terms of the numbers that I was showing, but not to quite the level of somebody who just owns a duplex.
Yes, question.
Do you know if nonprofits such as Common Bond or ION use something like RealPage?
I don't know for a fact. I would guess not.
Yes, I'm sorry. So the question for those who are not here is if we know that local nonprofits, if local nonprofits like Common Bond or Aon use RealPage.
Yeah, I guess I would think not, both because their mission and then also just the cost. So we actually subscribe to a service similar to RealPage. That's not quite, it's a lot smaller, not quite the market share of RealPage, is where all the numbers that I got came from. And it's very expensive, just to even like
Oh.
subscribe to get those, to get the information. So in order to actually participate, I don't know the numbers, but in order to actually participate in terms of for the rent setting, I'm sure is very costly, so.
And the thing I would add is I'd be surprised if nonprofit entities would really see a financial benefit in doing this. So for instance, you'd mentioned Aon and Common Bond. So these are a couple local nonprofits. A big part of their inventory is government subsidized housing. So for instance, if it's a building that is subsidized through one of the Section 8 programs, there are a lot of kind of limitations on how it can operate. So one of the things is that someone who's in Section 8, their rent is a percentage of their income, approximately 30% of income. So if your income were $1,000, your rent would be paid at around $300, or there's some adjustments, but roughly that. And then the profit that the revenue that the nonprofit is getting that from those residents, but that's not covering their costs. And so the subsidy that they would get from the federal government would basically help them cover their costs. So I would be shocked if they would see a real benefit from having to do this, from doing this, because they're not setting the rent for the resident. They might be setting a rent in their negotiations with the federal government over what the subsidy is going to be, but they don't have kind of unlimited authority to do that, while the for-profit entities would.
It's just the rest of the units. So if they have a building that has a certain set aside for Section 8 or rent control, but then there's the market rate and sort of subsidizing the subsidized.
Right, so
I live in a common bond unit, I should say, I live in a common bond property, and I'm finding common bond has a lot of surprising things they do that I thought, really?
So there was a question related to what about the non-subsidized units in one of these properties? And some of the nonprofits have both subsidized and unsubsidized units. And then there are other nonprofits that are totally subsidized units. And so for a nonprofit that had subsidized and non-subsidized units, they still would have to figure out, is there going to be a financial benefit for them to pay to get into the RealPage umbrella to be able to set their non-subsidized rents at a level where it's actually going to pay off for them doing it. And again, I'd be kind of surprised. I think where you maybe will see this kind of rear its head would not be in conventional subsidized housing, but low-income housing tax credit properties. So those are a type of subsidized housing where the residents' rent is not pegged to their income, but their eligibility to be in the housing is income-based. So you have to have a lower income to be in it. And the rents are subsidized, but they're not subsidized as fully as someone who's in a Section 8 property. And so, and part of that has to do, it's a much longer conversation. I don't think the IRS really ever wanted to be managing a housing program. And so they've had it be very hands-off in terms of very kind of unregulated. So that's an area where I think the ownership would have maybe more ability to participate in a RealPage structure and maybe raise rents kind of connected to that.
Yes, question.
Thank you so much, Larry and Jordan. Really interesting. I work with Ed and Tony on our investor ownership research at CURA, and I wanted to kind of go back to Jordan's comment about like banning RealPage isn't the solution. I mean, what are some like policy solutions that you see to combat the tendency to maximize rents? And also, I do think there's a lot of like kind of implications on the subsidized market. HUD determines its fair market rents from market analyses. So if RealPage is jacking up rents, that's gonna jack up fair market rents, which is basically a public subsidy of private equity. Same with LightTech, and, you know, calling LightTech a housing program is generous, but, anyway. What are your thoughts on that? And like, where can this actually lead to like more structural solutions?
Yeah, and then just in terms of what you were saying at the end, one of the things with RealPage is they're very clear. In fact, they even use the phrase, you know, in their marketing thing, rising tide lifts all boats, when they're talking about each other as landlords. That meaning that like if you, right, I mean, usually that's a term we talk about in terms of, you know, understanding why, you know, helping other people also helps you. But yes, they see it as that, you know, if you raise your rents, that actually helps me because then I can raise my rents, you know, same as that. So that was the second part you said. First part, I mean, I think the one that gets policy that gets most directly at it is some form of rent control or rent stabilization. And I know that lots of people, you know, feel very strongly that even if you increase the supply, if you don't address it in terms of the price of it, then that actually doesn't address the problem with affordable housing. Just having more units out there doesn't do anything. So that's something that that we support, I think, in terms of as the, you know, kind of gets most directly at in terms of the price.
And I think the other thing that could be part of the equation here is just how big is big? How big is big? How big is too big to be legal? Okay. And so we see the Justice Department litigating over large entities like Apple and Google over their ability to essentially control where we go with our phones and browsers, right? And it's based on being so big to be able to essentially run that traffic. And so I think one of the conversations here beyond the coordination issue is there a point where a certain landlord itself is going to, or a group of landlords are going to have too much market control. And that, again, that's not something we've seen in the housing area, but this is a pretty recent phenomenon. But the idea of entities being too big to control a market is now almost a couple hundred years old. And so I think what we're really seeing here is housing getting to the point where it can act the way that other entities did and other markets.
It's really a point to mention. Amy Klobuchar again, did not expect that I'd be talking about her this much, but currently that it's there's no approval process for if one landlord wants to acquire additional units, no matter how many units it is. So the way that there is for mergers and acquisitions. So if I'm Blackstone, for instance, and I want to acquire another company, it has to go through a merger process and approval. But if I just want to acquire 6,000 units of housing, there's no approval process. Nobody looks at that. So Amy Klobuchar and others have actually called on the FTC to begin to do that, to actually look at kind of the impact of it, of acquiring housing. And there is in the single family rental market a lot of talk in terms of having caps on how many properties any one entity can own. A number of state legislatures, particularly in terms of it got a lot of attention here because of the group Inquilinos Unidos who were organizing tenants and because of the Attorney General's lawsuit. But in terms of the impact, single family rentals actually are a very small percentage of the overall market compared to in the Sunbelt states, where here the company Progress Residential owns 600 homes. They own 10,000 homes in Georgia. So, and there's a lot more attention in terms of the impact, particularly in terms of the home buyer market. So less concern about tenants and more about in terms of how it's impacting home buying, but where there are, a number of bills looking at how to cap, put a threshold on how many properties any one entity could own, single family rentals.
And I think there was a bill in the Minnesota legislature this last year that was going to focus on kind of the corporate ownership and rents. Can't remember if that was limited to seniors or not. But anyway, I think the good thing here is that the conversation that we're having here today is starting to happen all over the country with states and both the state level and the local level. I mean, you have San Francisco acting, you have Minnesota thinking about it, you have Congress some members of Congress thinking about it. So I think we're going to start to see a patchwork of legislative responses to this phenomenon.
Larry, when you were speaking about some of the litigation on this question, you noted that most of the cases are in pretty early stages, and it could take months or years to sort of go through the process. Are any of the courts, what happens in the meantime? Are any of the courts putting constraints on the use of this while the issue is being litigated, or do things just continue untouched while the litigation takes place?
Yeah, so I think there's a perception out there that the filing of a court case stops the bad thing from happening. And there are examples of that. So for instance, in Minnesota, if you have, if someone is harassing you or you're a victim of domestic violence, you can file a case and ask to get for a restraining order. And a lot of times that restraining order will happen at the beginning of the case. It'll be a temporary restraining order. And so that will say to, for instance, the harasser, stop this conduct, maybe stay a quarter mile away, things like that. And so you have those types of cases. That's really more the outlier, that you have a decision at the early stage of a case stopping an alleged illegal act from continuing. That's the outlier. More often, the case has to be fully proven, and at the end of that process, then the court issues an order saying either this practice is illegal or it's not. And if it is illegal, what are the ramifications of that? Is there a monetary amount that needs to be paid? Is there conduct that has to stop happening? Okay. And so I haven't dug into the latest kind of event in each of these cases, but I did look at some of them, and they're essentially in the pretrial mode where they're having scheduling orders saying this is when you got to produce your information and that type of thing. So the short answer is I'm not anticipating any kind of judicial rulings that stop the practice, in this year. I think it's certainly possible with the cases that started a couple of years ago that they might be kind of ripening to that point. That's kind of part of the problem, and one could say the benefit or the problem in this country is that a lot of processes that affect policy are not fast. Okay, I worked on a proposal to have low-income tenants in public housing have a right to a free attorney when they're defending an eviction case saying they've done something wrong. So these are kind of like the poorest of the poor. I first proposed that in 2016. It just got passed in 2023. Okay, and so that just gives you an idea. Legislatively, things often move pretty slowly, and the judicial system has some of those aspects as well. And some of that is good. I mean, the defendants, even though I'm not fans of them, they do have their rights to due process, and as other defendants do. And so there is a good quality to litigation moving a little bit slowly so that nobody is kind of getting trampled in the process. But then the downside to that is a potentially illegal predatory practice continues while that's percolating.
Other questions have we received?
Nope, not yet.
Jordan, you were talking about the big actors here, and I think your point was that some of these are private equity. The others are real estate investment trusts?
Yes, exactly. So, yeah, and I think some of the other largest landlords in the country are publicly traded REITs or REIT, real estate investment trusts.
Yeah, and what's the important difference between those two types?
Yeah, in terms of tenant experience, not a lot. I think, one of the differences is that with the REITs, they're in general, the income comes mostly from the actual operation of the property and needing to be able to have to distribute profits to their investors much more in terms of over a period of time. With private equity, it's really about they need to, and private equity investors are typically for a short period of time, 3 to 7 years. After which point you kind of want to get all your money back, plus the profits. So it's really about how to maximize the profits in that short period of time, and then get some big windfall from selling the property. Not in all cases, but especially the ones when there are investors, such as I was looking at showing with when pension funds are invested, that they are investing for a certain period of time and expect then to get all of their money back plus profits in a way that they're not going to get just through the monthly paying of rent, that they actually need to sell the asset, or in some cases make, have a spin-off company that they take public.
So in the face of lawsuits that may take years and don't provide any immediate remedy, then clearly even the existence of a lawsuit suggests that working for local ordinances is still an important thing to do, even in the face of existing lawsuits out there.
Yeah, I agree with that, because, let's say the lawsuit in Arizona is successful. Okay? Well, that's only under Arizona law. Let's say the case in DC is successful. That's only going to be under District of Columbia law. So those ones are not going to have national impact. Okay? Now, the federal ones, the ones that are going under the Sherman Act. So let's say you have a decision out of Washington State that this violates the Sherman Act. Well, then that doesn't necessarily stop the other court cases from going on. So sometimes the reason why cases get to the United States Supreme Court is you have cases going up that have contrary decisions, right? So you have one saying A and you have one saying B, and at some point the Supreme Court would have to weigh in and say it's either A or B or something else. So waiting for litigation is kind of just deciding, well, I'm just going to sit on my hands. And that doesn't help people that are dealing with ramifications of a potentially illegal and predatory kind of set of actions that are going on. So that's why you see, a city like San Francisco taking action, and I think we're going to see other bodies take action as well. And I think that's a good thing. I mean, that is part of democracy. That is part of basically representative bodies looking at what's going on with society, and is this a good thing or a bad thing? And if it is a bad thing, should it be prohibited? Should it be regulated? Should it be shifted in some way? And that's essentially why we have city councils. That's why we have legislatures, and that's why we have Congress. Sometimes they do their work, sometimes they don't. Minnesota, from my view, the last couple of years have been pretty productive years with basically the House and the Senate and the governor working together to say, these are some things that have been sitting around for a long time that need to be addressed. So I think it's a good thing that legislative bodies are starting to look at this.
Larry, in the lawsuits where they name RealPage and then a number of individual landlords, how does that work in terms of defending that? Do they all need to defend it together as one? Does each company individually kind of negotiate with the plaintiff and can reach their own terms of settlement and get removed from it, or how does that work?
Well, in general, when you have multiple defendants, it's up to them to decide, are they going to coordinate or are they going to kind of go separately? You certainly hear of cases, some of the litigation against former President Trump over things related to the last election. Some of those cases had multiple parties. Some of those did plea deals and kind of opted out and cooperated with the prosecution. In civil cases, the same thing can happen. Now, what I don't know is, did RealPage have like an indemnity agreement with the landlords that says that if you get sued and we get sued, we run the whole thing? And I wouldn't be surprised if they had some sort of agreement like that, so that the landlords that were participated were essentially saying, we're not gonna get peeled off. I would be a little surprised if they hadn't done something like that. But again, these cases are all pretty fresh, and it's really, I think, at some point in these cases, you might be thinking, okay, well, what's a trial gonna be like in a case like this? Well, there may not be a trial in this. This may be after both sides do their exchange of information, that both of them will basically say to the judge in that case, we think you've got enough information to decide as a matter of law whether this practice is illegal or not. And so in the lawyer biz, we call that a motion for summary judgment. So summary judgment is when you're getting a court to issue a decision based on these are the facts and this is our interpretation of the law without having a trial. And you only do that if the court decides that there aren't any material facts in dispute. So if it gets to a point where there is agreement that this is how all of this operates, then the court could entertain motions for summary judgment saying, okay, based on our agreement of what the facts are in this, that we can issue a decision on it. Now, it could be that there won't be an agreement on the facts because the defendants are going to spin it one way and the plaintiffs are going to spin it another way, and so then it may end up going to a trial. But whether it goes to a trial or not, I would be shocked if there aren't motions for summary judgment, and then if the court denies those motions, then it would be scheduling a trial. If it granted the motion for one side or the other, then the side that lost would be appealing it up a stage.
I noticed in at least one of the lawsuits, the named defendant was not RealPages, but Yardi, which is another real estate information firm. So how many other firms out there that are doing this kind of algorithm type of providing this kind of service to landlords? Do you know?
I know there's some, but that none kind of are close to the market share that RealPage has. Yeah, Yardi is kind of another one, but again, it's kind of a much smaller scale.
And Yardi is the defendant in the case in Washington State.
Perhaps because
Yardi is who we have a subscription with in order to get information. So
very good. We will continue to entertain questions if there are any. If you are tuning in virtually, you can email the address that's on the screen. We have one question in the audience here.
I'm not just scrolling on my phone, by the way. I'm not trying to be rude. Do you know about Fulton Realty? Are you familiar with them?
I'm not.
It's local. I was trying to see what they're up to now because I've been invited. I feel like a spy sometimes going to their gatherings. They hold forums, regular forums, where they bring in outsiders and teach them how to make money. One of the whatever it is now is reserve your spot, but they don't say what it is and hit spot and then it's not connecting. But one of the last ones I could get in is how to go from 1 to 1,000 doors. But that's their idea, is they trying to teach people how to be mega millionaire realtors. They had, when Heather Worthington was still the public works director, she entertained a large group and was talking about, the Comp 2040 plan and it was at one of these gatherings that she was known to have said, that she was quoted, saying that familial wealth and housing, your familial wealth in your housing is dead. That concept is dead. Go out and start a small business. Because small businesses never fail. I have a dislike for that woman. So they hold a number of these different forums where they bring in developers and realtors and educate them. I almost got the member of another one where they were how to make money during the pandemic, another one was about ADUs, and that makes sense. how to make the most out of the ADUs. There's just something sort of sinister about the way they do things. So I keep them on your radar because they sound like kind of people who are benefiting from RealPage. Like I said, I feel like a spy. I don't own any property. I'm never going to go in there. I'm never gonna be, but I go to these things, you get some free wine, you get some free snacks, and you find out what the other side is doing.
Yeah, and again, part of the issue here is not about saying that landlords can't make money.
Exactly.
Right. It's really about, is there a point where they get so big and they get so coordinated that they are essentially controlling the market rather than reacting to the market. So when I was a landlord, I was reacting to a market, right? And so renting out a house, and so I'm looking at, what are the rents in the area, and then pricing it kind of within that structure so that I could cover my mortgage and not go in the hole and work with that. But I didn't have any ability to essentially say, I'm going to be the market rather than react to the market. And that's what we're really looking at here is both the size of the landlords, because the size of the landlords in and of itself doesn't present the problem. It's the combination of the size of the landlords and the coordination of the landlords, the two things that are basically presenting this problem, in my view.
And sharing information that's not public, that
Right.
exactly, as you as a landlord, you can see what the market is, what other people are charging, and you're gonna, pay attention to that to figure out how much you should charge. So with RealPage, the lawsuits are saying that it goes beyond just kind of looking at other ads for how much, for apartments to sharing information that is not public.
Anytime there's a lack of transparency,
Yeah.
there's a problem. And I really love that line. How big is too big to be legal? That should be a
So
bumper sticker for many,
on the issue of how big is too big to be legal, oftentimes landlord identity and ultimate ownership is easy to obscure. And entities hide behind different LLC names, et cetera. How much of an impediment is that to understanding the real size and real influence on the market of an operation like RealPages? Is it an important impediment? Does it present itself as something that maybe public policy needs to address?
I think so. I think for, and this might be something, that has kind of come up in terms of when you look at in terms of with city planning departments, that oftentimes for a city, if you wanted to know who the largest landlords were in your city, you actually wouldn't be able to know that you don't have that information handy because, as you said, so with apartments, each apartment is owned by a separate LLC. So it would require, that's not clear, who the beneficial owner or the real owner is. So you'd have to individually, if, unless you have some requirement that landlords, share that information with you, you'd have to individually kind of look up, which is something that we've spent many hours doing, look up each LLC in order to see who the actual owner is, and then aggregate it all yourself. So I think it makes it very hard to be able to know what the real situation is.
And the other issue that's presented by that, and again, I started seeing individual apartment building LLCs happening like about 25, 30 years ago. And the way it affected tenants, so let's say you have LLC A and it owns this 20-unit building. And then they own this other 20-unit building. So you're representing tenants in building A. And it's got all these repair problems. And so you're suing the landlord to get the repairs done. And you're suing this LLC, which is for building A. And if it's undercapitalized, meaning it doesn't have a lot of assets behind the building itself, and you get a judgment against this LLC saying you got to pay this money, it can say, sorry, don't have the money. Well, wait a minute, you guys own building B. Oh no, that's LLC B, that's not us, right? Even though both LLCs are basically run by the same people or same entity. So it allows landlords to essentially capitalize their properties just to the point that they need to operate them, but they essentially be shielded from litigation that would have a price tag beyond how they've capitalized their property. And so that's been something that's been bugging me for a long time. Now, for the most part, when I've been suing landlords to fix up their properties, and again, most landlords are fine. They maintain their properties because they see it as something that needs to appreciate, and they don't need to be sued to get repairs done. So unfortunately, I don't really know the good landlords that well. I just know the ones that I've had to sue. And so this has been a problem for a long time. Now, it hasn't had a dramatic effect because a lot of times the price tag of the litigation is within the capacity of the LLC to do it. But that's another problem, and this was really a concerted effort. You know, if you go back 40 years, you didn't see LLCs for every building. You had landlord A and they had 20 buildings around, and that's what it is. But this was basically an effort to kind of shield themselves from liability, so they'd only have none of their other assets would be affected by litigation under one building.
We're about at the end of our time. Any other question? Yes.
Below exempt questions. I mean, like, everything we're talking about today is not like a flaw of the system, but just like the system operating as it's intended. I mean, right? Like you said, private equity's goal is to buy low, sell high. What can we do, or what can like public policy makers do to like disrupt it at the buying phase and the selling phase? Like, how can do we have hope under, really?
Yeah, and the buy-in phase, I mean, I think it would be about, you know, if there were caps in terms of, on how many, you know, properties or how many units any one entity could own, would be the way to disrupt it there, to require there to be some mechanism, for approval. So for instance, I mentioned in terms of, the way that there are with mergers, that there has to be a approval of that. I think the other thing is just other, you know, other tenant protections. So there's rent, then there's also, you know, we've seen, especially with corporate landlords, adding on new fees. And then there's a question of, you know, tenants didn't know about those fees, or they're hidden because they weren't, you know, upfront. And if it wasn't, you know, so I think there's also, you know, policy and, you know, every level, local, state, federal, that could also address fees. And then other, you know, other tenant protections. It doesn't get it, I guess, the too big part, but at least in terms of protecting tenants, such as Larry had mentioned in terms of right to counsel for tenants. So being able to, you know, have kind of a right to have a lawyer at eviction hearings. It's kind of another policy. Just cause evictions, so that you can't just, you know, is another policy, so that, you know, the landlord can't just decide not to renew your lease because they want to charge somebody more to get you out of there.
And sometimes you can do something on a policy front that doesn't ban a practice, but essentially makes it unprofitable, okay? So like, when I've had lawsuits against slumlords, their business model is to maximize income, minimize expense, so they don't repair anything. Okay, when you sue them and make them repair their places, it basically screws up their model. And I've seen slumlords exit the business because once they had to maintain their properties and they didn't have the profit that they thought they were gonna have, they just said, well, I guess I'm done, okay? Now, the same thing could happen with essentially something related to this industry, is to either regulate it in a way, rather than necessarily prohibit it, but regulate it in a way in terms of what are rents, what is too big, those types of things. And lastly, when that's done on a local basis, it makes it harder for something to become a national thing. So for instance, one of the laws we got passed a couple years ago requires landlords to disclose mandatory fees, right? So let's say there's a fee that says every January, there's a $200 administrative fee. Okay? If that's a mandatory fee, it has to be disclosed. And the reason for that is so the tenant can look at the lease and go, or look at the advertisements, look at the lease and go, okay, this is really what my annual housing cost is gonna be. It's not just gonna be what you're setting as the rent. So the more that states and localities kind of put into play tenant protections that are gonna make it difficult for the RealPage world to operate in that state, it's going to be a less viable entity because these national organizations are gonna maybe say, okay, maybe we're not gonna do business in Minnesota, maybe we're not gonna do business in San Francisco. And then that reduces kind of the sales pitch for a RealPage saying you can do this all throughout the country.
On that note, I would like to thank our speakers today, Larry McDonough and George Ash, and invite you all to stay tuned for information about about our next CURA Housing Forum, the topic of which has not yet been determined. But there will be a next one. It will be in November, and be on the lookout. We'll be in touch. Thank you so much.
Thank you very much.
Thank you.
Good one.
Yeah. Right.
Yeah, I talked to your colleague, Matt.
Oh, okay. Yeah, okay, great.
Nice to hear you.
Thank you.